Hello, this is Module 21, Trade Secrets, Conditions of Protection. The aim of this module is to explain the principles and concepts of trade secrets law. As there are relatively few cases in connection with trade secrets law in India, and because trade secrets law is judged through the principles of common law, this module will also examine cases and relevant principles from other common law jurisdictions such as the United Kingdom and the United States of America. A trade secret is one which may be used in one's business which could give a person an advantage over its competitors who do not know how to use it. Thus, the cost of devising the trade secret and the inherent value of the trade secret are the underlying reasons that the law operates to protect the holder of the secret. In general, a competitive advantage is only conferred upon the holder of intellectual property in exchange for transparency and disclosure. This is most clearly seen in the context of other intellectual property laws such as patents, where disclosure is rewarded with patent protection. However, unlike other forms of intellectual property rights, the law only protects trade secrets when it remains, as the name suggests, a secret. Thus, a trade secret is any information that can be used in the operation of a business or other enterprise that is sufficiently valuable and secret to afford an actual or potential economic advantage over others. Trade secrets laws operate once a trade secret has been unlawfully disclosed. Unlike most other forms of intellectual property rights in India, trade secrets law is not codified but is protected by the principles of common law. Indian courts have therefore relied on common law cases and principles in its own decisions on trade secrets. In the United Kingdom, the seminal case that discusses the elements of a trade secret is Coco versus A.N. Clark. In that case, the court held that to be considered a trade secret, the information must have the necessary quality of confidence about it. It must have been imparted in circumstances imparting an obligation of confidence. It must be an unauthorized use of that information to the detriment of the party communicating it. This precedent and other relevant principles taken together form the basis of the jurisprudence of trade secrets law in India. We will now discuss the various elements of trade secrets law. The first element is that subject matter must be confidential. In India, courts have interpreted confidential information in a manner similar to the interpretation in the United Kingdom. In the UK, the leading case is Saltman Engineering versus Campbell Engineering, which holds for information to be confidential, it must have the necessary quality of confidence about it. Namely, it must not be something which is public property and public knowledge. The standard for information to qualify as being trade secrets by the courts in the United States, however, is lower than its UK counterpart. In the United States, the courts do not require absolute secrecy. In the United States, the test is one of reasonableness. Has the plaintiff taken all the reasonable steps considering the nature of the information sought to be protected as well as the conduct of the parties? Where information has been condensed into tangible form, it is always much easier to identify the subject matter sought to be protected as a trade secret. However, where the information sought to be protected is an idea, proving that the disclosure of such information carrying an obligation of confidence becomes more difficult. In India, the emphasis in this respect is on the form and degree of development of the information or idea. In Anil Gupta versus Kunal Das Gupta, the Delhi High Court observed, when an idea, concept, or a theme is original, laws must ensure that such like people are rewarded for their labor. Using this rationale, the court in this case protected a concept for a reality television show as a trade secret. Thus, the subject matter of a trade secret need not be in its final or even tangible form to receive protection under trade secrets law. We will now discuss the second element, the existence of a confidential relationship. A confidential relationship must exist for the information to continue to be regarded as a trade secret. In other words, common law jurisdictions have held that the information will remain a trade secret despite disclosure if such disclosure was made under limited and necessary circumstances. Such confidential relationship may be formed either expressly or impliedly. We will now discuss the various sorts of disclosures. Limited disclosures. In the United States case of Metallurgical Industries versus Fortec, the court explained that disclosures may not be construed as destroying the secrecy of information as long as the holder of such information can present evidence such as the information was disclosed only to businesses with whom it was dealing and not via a public announcement or to further the entity's economic interests. The court also stated that evidence of confidential relationships with these two companies would help strengthen the limited nature of such disclosure. Indian courts have recognized another form of such limited but permitted disclosure in cases where courts have ordered documents to be placed under seal or designate specific persons as a part of a confidentiality club. This enables not just the lawyers but also the courts to function efficiently and comprehensively when adjudicating a case in which the underlying disputed subject matter or incidental data disclosed is confidential.